A new poll looks at the popularity of AR-15s as a federal judge upholds Delaware's ban on them. Plus, Pepperdine University's Jake Charles on the massive effect the Bruen decision has had on lower courts' view of the Second Amendment. That and more on this episode of the Weekly Reload podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and check out our free membership options today if you want to, or our free newsletter option. So I got a phone call in the middle of my introduction. I usually speed right through that one. It's almost hard to comprehend. I've been able to get that down so good. But anyway, yes, you can head over to thereload.com and sign up for our free newsletter if you want to keep up to date with the latest gun news in America. Or you can buy a membership if you want to get exclusive access to hundreds of pieces of analysis and stories that you will not get anywhere else. This week, we are talking about the effects of the Bruen ruling from the Supreme Court on how lower courts have handled Second Amendment cases. And for that purpose, we have a special guest, associate professor from Pepperdine University, Jake Charles. Welcome to the show, Jake. Thank you for joining us. It's your second time on the podcast, I believe.
Yeah, that's right. First time at Pepperdine, though. So thanks for having me, Stephen.
Yes. Jake used to run Duke's Firearm Law Center, for anyone who isn't aware of that. But now he's a full-time professor and is doing his own research as well. Published you published a revised paper that included some new estimates of the effects of Bruen. Can you just tell us a little bit about the top line results of that?
Yeah, absolutely. So the paper is kind of a broader discussion about Bruen, and in the revisions that I just did, I included this analysis that I'd done of the 8 months following the Bruen decision in federal court. And kind of the top line numbers were that we were seeing a lot more cases struck down in the immediate aftermath of Bruen than we did in the aftermath of Heller. So I have the numbers right here. So there were, out of 174 total federal court decisions that were issued in that 8 months, there were 12 civil cases in which a court found at least one of the claims prevailed in the case that the statute or government action violated the Second Amendment, 9 in criminal cases, and for an overall 21 out of those 174 decisions for a success rate of about 12% in the first 8 months in total decisions.
Right, which might not sound like a lot.
By claims.
Right, that might not sound a lot to the average person listening, but how does that compare to after Heller?
Right. So it might not sound a lot in the abstract, but if you remove cases that were challenging, say, the federal law that bars those with felony convictions from possessing firearms, it shoots up dramatically. So for the civil cases alone, the success rate is 31%. And I don't recall off the top of my head what the civil success rate was after Heller. But in the 8 years after Heller, all claims had something like a 9% success rate, including those ones with the felony prohibitions. And so a 31% success rate, 1 in 3 of these lawsuits are having at least one claim prevail. In the civil lawsuits where someone's challenging it not as a result of a criminal conviction, is a pretty high success rate overall, and particularly in the 8 months that we've seen since the Bruen decision. Yeah,
it's a dramatic difference. And I think in your analysis, you found there were 0 cases in the immediate aftermath of Heller that first year.
That's right. Yeah,
nobody won.
Yeah, relying on this a study from the 8 years in the first year, the first 6 months after Heller, no challenges were successful out of 70 different claims.
Right. Yeah, and in that same paper, there's from there's 2 other professors, right? Eric Rubin,
Joseph.
Yes, and so they did an analysis of Heller several years later to see the effects of that law, and so that matches up against your analysis, which shows a pretty dramatic difference. I mean, I think it took 4 years for there to be 30 plus claims that were successful Second Amendment claims after Heller, and that also includes the 2 years after McDonald.
Yes, exactly. Yeah, 4 years. Yeah, roughly 4 years to see the same type of lower courts striking down laws we've seen in 8 months since Bruen.
Yeah, and we'll get into some of the, why this is, and talk about some of your thoughts on Bruen and
Yeah.
and some of and these effects. But let's just get into some of the more the details of the specifics about these challenges that we've seen and which ones have been successful and which ones haven't been as successful yet. Because you did a detailed breakdown of this in your paper, which people, by the way, can read, and I recommend people read your paper and all. It's a good resource for this, and it's good to have those differing points of view. I know sometimes on this podcast it can be people from a lot of the pro-gun point of view more explicitly, and so that's why we like to have people on who are more, in your case, you're more critical of the Bruen ruling. Not to say that you're anti-gun or anything, but you come from a different perspective than, for instance, Costas Morris, who we've had on a number of times, who is a pro-gun litigator. So it's good to have that sort of perspective balance out there so you can understand where everyone's coming from. But your paper details these specific challenges and how they perform. Can you give us a breakdown of that?
Yeah. So if you look at the challenges, and I should say one kind of big caveat at the beginning is I only looked at federal court decisions. So there are some state court decisions. There's some state court challenges to state convictions. There are some state civil challenges. I only looked at federal court decisions, and I only looked at the ones that were uploaded to the Westlaw database, which is one of the main databases for uploading, for when courts upload their decisions. So there might be decisions that were issued in the 8 months that weren't there, but that's kind of one big kind of caveat when I talk about these. And I'll say one other thing, which is that I just did a blog post on the Duke Firearms Law blog where I linked to the spreadsheet that I used. So if folks want to look at that spreadsheet, they might say, oh, you should classify this case differently. That's fine. So I kind of disclose the ways. But
yours is still the most comprehensive. I'll say that. Like, I don't think I've seen any other analysis attempt to put numbers to these things yet. So it's very valuable.
Thank you. Yes. So hopefully the spreadsheet's there. If people want to classify differently, they can. But when I looked at the cases and I grouped them by types of claims that were raised, you can see there's certain types of claims that are finding more success than others. So New York and New Jersey changed the private property default rule, which is the background norm had been prior to these laws that you are allowed to carry on private property unless the owner objects. And both laws switched the default and said you're not allowed to carry on private property unless the owner gives their consent. And there's been, I'm counting 5 different challenges to those types of laws. In which courts have said that's an unconstitutional thing to do. So those are 5 for 5 success rate.
100%. Yeah.
And then similarly with some of the changes in state licensing laws post-Bruen, so the states that changed their laws to comply with eliminating the may issue requirement, but then adding or specifying their good moral character or their training requirements differently, there have been, at least within some categories of those claims, courts have said that those licensing revisions have been unconstitutional. So I classify those as 3 out of 3 because in the classification of licensing laws, there's been success on those. And then kind of one that's a little bit more broad ranging is to sensitive place laws. So some of these are to new designations of states that have added places to the set of places where a person cannot carry guns. Some of them are to old places and to appeals from criminal convictions from those. But those have had a more than 50% success rate. So I count 13 claims in there, and I think that means 7 of them have been successful. And that's not including kind of every specific designation. It's not breaking it down separately into zoos and playgrounds and mental health facilities. But as a set of claims about sensitive places, about 7 out of 13 of those have been successful. So those have been kind of the buckets of the most successful types of claims. But there are, in almost all categories, and excluding mostly just the criminal convictions, there have been some successes in most categories of gun laws that I've charted.
Yeah, but there were a few that were 0%, right?
Yes, and I think most of those were criminal convictions, and so they were appeals from criminal convictions. So
I believe that was, if I'm remembering correctly, it was things like the bail conditions and prohibited persons list, like nonviolent felon challenges.
Yes. Yeah, the felon one has been entirely unsuccessful. There's been some success on other prohibitions in federal law, like domestic violence restraining orders. But yeah, bail conditions, sentence enhancements, convictions for unlawfully using a weapon during a crime. All NFA violations have been dismissed as not violating the Second Amendment.
Right. Yeah. So there's a clear sort of delineation between how the lower courts are looking at certain claims and how they're looking at other ones. And some of it's perhaps not surprising, right? Those three big ones really deal directly with gun carry, which is what was at play in Bruen. And so it's perhaps more, an easier lift to say, well, this is what the court said on this issue, because that's what the court was specifically talking about in Bruen. Whereas you get further away from gun carry, obviously they put a standard in Bruen, which we'll discuss, and we'll discuss some of the critiques that you have of it. But it's still further away from what they were explicitly talking about in the case. So perhaps that explains some of this. One of the interesting things to me, and I'd be interested in your point of view on this, is that nonviolent felon prohibition challenges have been entirely unsuccessful so far. When this was kind of something before Bruen that had been seeing some success, there was a federal case that where I think the Second Amendment Foundation had won a case involving nonviolent felons in Pennsylvania, I think it was, and you had for instance, Amy Coney Barrett, the Supreme Court Justice in Cantor. It was a dissent, so the plaintiff still lost, but it was her view that nonviolent felons shouldn't be prohibited for life from owning guns. So it's interesting to see in the wake of Bruen, which set this higher standard of review for gun laws, that this is sort of regressed a bit, at least early on.
Yeah, that's exactly right. That before Bruen, there was sort of a developing circuit split about when a person who had not been convicted of a violent felony was raising an as-applied Second Amendment challenge. So saying not that this law is unconstitutional in all of its applications, but as applied to someone like me, or to me in particular, based on my circumstances and conviction, it's unconstitutional. And you're right, the Third Circuit had found this unconstitutional as applied to someone who did not commit what the court characterized as a serious crime. It said there was a serious crime limit on the kind of underlying conviction that could deprive someone of their right to keep and bear arms. Other courts have said, no, it's actually there's a virtuous citizenry notion. And if they weren't, someone who's non-law abiding is not virtuous, and therefore the legislature can strip them of their Second Amendment rights. And you're right that Justice Barrett, when she was a judge on the Court of Appeals, and several other dissenting judges on Court of Appeals also said that this cannot be extended to nonviolent for folks who have underlying nonviolent felonies. But none of those claims have been successful so far in the trial courts. So it's possible that there might be different rulings once these cases go up on appeal. But I found it at least surprising that, as you said, Bruen makes the standard harder, at least it seems to be harder for the government to meet than does normal means and scrutiny. And yet, even though some of these claims found success before, none of them are having success now. And this might be one area in which, as some courts are saying, it makes it easier for the government to sustain the constitutionality of a law, because I think we can imagine that there are situations in which somebody has a nonviolent conviction, and it would be really hard to justify on public safety grounds why taking their firearms away would benefit the public. So there's this law review article called "Why Can't Martha Stewart Have Guns?" And she's a perfect example of someone who is barred by federal law from possessing guns for the rest of her life, unless she gets a presidential pardon. And yet, if the government had to satisfy means and scrutiny, it'd be hard pressed to introduce evidence that someone who's convicted of whatever kind of fraud offense that she was convicted of makes the community safer. Right. Whereas if the government can say, look, there's a historical tradition of taking guns away from people who are untrustworthy or who broke the law for any kind of infraction, whatever that may be. If that's what the historical tradition is, then that means the government has greater leeway under a historical tradition test than they might have if they had to satisfy means in scrutiny.
Yeah, no, I think that's a valid point, and one of the critiques you've seen sort of from the right about the text and tradition standard generally, so I mean, obviously, I think most people in the gun rights movement are very happy with this current standard, so it's not exactly a large percentage that have this that cite this concern as a reason not to want the Bruen standard, but it is an interesting thought, and certainly felons in the founding era, I think, often were executed.
Yes.
Now, of course, what a felon was has changed quite a bit since that time, and that may come into play as well as these kinds of cases progress. One of the interesting things, I don't know that this is a surprise, but it's certainly not something that was a goal of the gun rights movement. I think the legal movement in the wake of Bruen are some of these rulings dealing with, felony indictments and the sort of odd, the unique prohibition that surrounds them. There's a ban on like obtaining guns, but not on possessing them.
Right.
And that got blocked by a federal judge. And then also
a number of them, I think at least 4. Yeah. So
right.
36% success rate for those types of claims. Yeah.
And these are some of the criminal claims that are kind of more of a wild card situation, because it's not like something that's planned ahead where the Second Amendment Foundation or Firearms Policy Coalition or the NRA or whoever has an idea of what laws they want to challenge. This is more like criminals being convicted of crimes, and then their defense attorneys. Oftentimes, these are brought by public defenders. Actually,
that's right.
So far, are saying, well, look, there's under this Bruen standard, there may be a Second Amendment issue here.
Yeah.
And you've seen that with the felony indictment prohibition, and then you've also seen it with, of course, the more newsworthy and controversial one, which was the domestic violence restraining order prohibition. Both of those came out of criminal cases.
Yes.
And maybe I don't know that surprise is the right word, but not something that was part of the gun rights movement's plan for how to go after, how to pursue Second Amendment claims. So can you talk a little bit about that?
Yeah, and I'll throw in one more, and it's the ban on firearms with an obliterated serial number, right? Another one that's kind of had success post-Bruen that I think you're right. I would say it was surprising to me how much success these types of claims have had post-Bruen, because prior to Bruen, we would often say, even if the court goes to a historical tradition test, it seems very unlikely that a court is going to say that someone who has been found by a court to have committed domestic violence and be a threat to their intimate partner is going to be allowed to possess guns. That was kind of, I think a lot of us thought that seems unlikely to happen even with a historical tradition test. And yet we've seen multiple courts say that's just the case. And in the other context,
and actually, just real quick, that might actually be the next Second Amendment case that the Supreme Court takes, right?
I think there's a decent chance it will. The government just asked the Supreme Court to review the case from the Fifth Circuit, and so the court's going to have to make a decision on that one. That's probably going to be the first major case that it's going to have to decide whether it takes or not. And I have a hard time seeing that all the other circuits will agree with the Fifth Circuit's interpretation. And so it's probably going to be likely that there'll be a circuit split by, at least not by the time the court decides whether to hear it, then certainly by the time the court decides the actual case. And so you're right that these are not kind of strategic lawsuits that are filed to benefit gun owners generally, right? They're just defenses that are brought up in the course of a criminal proceeding. It illustrates one of the ways in which Bruen's test is difficult for courts to apply to new situations, and particularly where they don't have the kind of briefing that they have in a civil case, right? So if there's a civil case filed, then there are experts introduced, there's the resources from both parties, there's a discovery process. You don't have that kind of thing going on the criminal side. These are often happening in the context of a motion to dismiss the indictment. And then there's a short government brief in response, but there's no amicus briefs usually filed in these cases. And so the courts are either, some have said explicitly, I'll conduct the historical inquiry myself, or they're simply saying it's just the fact the government hasn't met its burden here. And so as applied on these facts is unconstitutional.
Yeah. Have you been surprised, by the way, at how often you see judges going out of their way to do their own historical analysis when it's really explicitly not covered in Bruen? I mean, Bruen really puts all of the onus on the government. But regardless of that, you've seen a number of judges do their own analysis and sort of in the absence of the government doing. I mean, I think Antioch in New York is a really good example of that. That judge, that was a really fascinating case for a number of reasons, right?
Mm-hmm.
That judge ruled that the plaintiffs didn't have standing at first, but then he also kind of explained to them how they could get standing.
Right.
And so
why the laws
that.
would have been unconstitutional. Yeah.
Yeah. And then when it came time for once they got past the standing requirement, he was sort of explaining, he did the analysis, or he did the historical legwork for the government, who I guess just kind of, he seemed to, at least in his view, refused to do it themselves, which he didn't need to do. He could have just said, under Bruen, if you don't give me anything, then you lose. Yeah. And then he also sort of rewrote the law. I've never seen that before. I'm not a lawyer, and I'm not a researcher like you are, but I've never seen a judge say part of this law can stand the way, but only if. But he added his own exception to it. I believe it was the church, the church ban, where he said this can't stand except unless it has this exception. So I'm just going to put this exception in the ruling.
Yeah. And like in an earlier iteration, he had rewritten the moral character requirement, explicitly kind of said like, and interpreted this way, cross out these words and add these words. I think that's a really rare thing to see in a judicial opinion, that a judge is kind of saying, here's the words that you have to construe the statute in this way. Like I'm rewriting the statute for you. I think that's incredibly rare. So that's one case where we see a judge kind of saying, I'm going to undertake the task of historical inquiry. We've seen it in a couple of cases out of the Western District of Texas, and Judge Counts in particular, who has struck down a couple of laws on Second Amendment grounds. But in other cases, he's upheld them, and he said, look, I think I have to do the historical inquiry myself, because otherwise it might be the case that the very same law is unconstitutional in one court and constitutional in another court, not based on judges' differing views of what the history means or how to interpret it or whether it's analogous, but just based on whether or not the government introduced, filed it in their brief in time. And so the court there said, I feel an obligation to not have that kind of disparity, so I'm going to do the historical inquiry. And, we could debate whether or not that's the proper role of a judge, or maybe whether that is a good thing that a judge should be doing by not trying to create disparities, not striking down laws if there is evidence it knows about, even if the government hasn't introduced it. And we could talk about whether, it's right for Bruen to say, the principal party presentation, which is the government, has to introduce this kind of evidence to sustain its burden, whether all that's also, a good standard.
Yeah, I mean, and we certainly will discuss that, because I know that's a significant part of this paper that you've revised and published. But I mean, it does feel like a sort of growing pains after this new rule has been adopted by the court, this new standard. And I mean, honestly, a lot of growing pains on the part of the government, and not really. It seems to me, at least, that they're supposed to be the ones who provide this evidence, and if the judges feel like they're doing such a poor job of that they have to go out and do it themselves. I mean, I think that maybe speaks to the lack of preparedness on the part of most of these states that are defending these laws. Mm-hmm. But, also just the early stage that we're in post-Bruen, because, some people like Duke Firearms Center, Law Center, have been chronicling historical gun laws for, I presume, this exact purpose, or not entirely, but largely because, people saw this was perhaps the direction the court might be headed in, looking at these historical laws for guidance on what's modern laws are constitutional. But certainly a lot of governments weren't doing that, it seems like.
Yeah, right. And you might think when a state's passing a new law, like in New York and New Jersey, you could say they should have been prepared for this because they knew what was happening.
Yes.
Maybe even differently situated than like a local prosecutor's office who just has a claim raised in a case that they're prosecuting, that there's a Second Amendment issue. And maybe the case was even brought before Bruen. So, maybe there's a difference between what kind of evidence you'd expect to see in a criminal proceeding versus a civil challenge to a law that's recently enacted.
Right. Yeah, no, and that's a fair point about, who exactly is defending these different laws. Yeah. Certainly New Jersey and New York's Bruen response laws were passed with the full knowledge of what the court had done and what the standard was. And so there's probably less sympathy for, whether they were prepared to defend those laws under that standard than, a local prosecutor in Texas somewhere trying to charge somebody for, especially that domestic violence case. Guy was very clear. I think that's an interesting one because he's clearly going to be prohibited very soon. Because
right.
He's the restraining order.
Actual conviction comes.
Yeah. He's got like 5 different things that he did that are going to make him a prohibited person. So it's a bit of an odd case in that regard. But but so let's get into some of more of the discussion of why we're seeing this sea change in the lower courts. And basically the Bruen standard itself is producing this. I want to get your take on I think you're fairly critical of that, and you're fairly critical of what we're seeing and the results of it.
And so, I'll say you mentioned that there are not every gun rights proponent is in favor of a text history and tradition test, and I often point to Professor Nelson Lund, who is a George Mason law professor and is strongly in favor of Second Amendment rights, held the previous Patrick Henry chair in Second Amendment law at George Mason. I think some of his critiques, even before Bruen, about the kind of test are what we're seeing come true, which is that the history is really hard to do, and it's hard to come to a determinate answer. That history does necessarily supply an analog for X or doesn't supply an analog for X. And his concern that he raised a few years ago was that what it's going to end up doing is drive the actual values decision-making below the surface. So whatever you think about intermediate scrutiny or strict scrutiny, at least the court there is putting on the table, here's the government's interest, and here's the evidence to support the government's interest. And do they match up or not? Is there enough evidence to support that this law is serving that interest? Whereas with historical inquiry, it's kind of hard. It's kind of opaque sometimes what rationales the courts are using to justify finding tradition sufficient or not. So in the Antoniuk case that you mentioned, the court at one point said, no, there's a historical tradition of banning guns in schools, but I don't think that applies to summer camps. Right? And it's not really clear what's doing the work in that analogy, right? What is the court seeing that's analogous or not between schools and summer camps? If you have a tradition that the court recognizes about firearm prohibitions in schools, what's different about summer camps? Is it that, they're not required, you're not required to be in them? Is it that they're not always children? Is it that they're in special places? The court really doesn't say, and Bruen doesn't give a lot of guidance on how to actually draw the analogies. But I'll say in general about the test, I kind of have 2 concerns about it. One is at the conceptual level about what it requires courts to do. And then one is at the practical level about how much guidance Bruen gave lower courts. So at the conceptual level, one of the things Bruen says is that you've got to find a historical tradition of regulating in a similar way in the past in order to sustain a modern gun law. And to me, that's just inconsistent with the concept of original public meaning originalism, which the justices and the majority in Bruen purport to believe, which is that the understanding at the time of the Second Amendment's ratification is what should guide interpretation in the present. And it's just not the case. I think we can all agree that all of the laws that the founding generation thought they could have enacted, did they necessarily enact? So it's entirely, not just plausible, but I think undeniable that there are laws that the founding generation thought they could have done and didn't do because there wasn't a need to do them. So it doesn't have to be related to guns at all, right? There are other things that they didn't do that they had authority to do. But Bruen essentially erases that category of laws that could have been enacted but that weren't enacted, because it says that you have to find an enacted law in the past that's similar enough to a modern one. And to me, that just it provides an inaccurate understanding of the scope of authority at the founding generation. So instead of looking to, did the founding generation think about X conduct as a right that was immune from government regulation? Bruen says, instead, look at the other side. Look at, did the founding generation actually legislate with respect to X? So that's kind of my conceptual problem with the Bruen test. And that's why I talk about it's giving this oversized importance to the role of historical silence, which is if government didn't do something, then they couldn't do something. At the level of pragmatics, I think there are just a lot of questions that Bruen didn't answer. So even if you reject my conceptual concerns or say that there's other answers for those, I think if you're a district court trying to apply Bruen faithfully, there are a lot of concerns that lower courts are voicing about the ability to do that task, because Bruen doesn't even say how many laws you need. Is it a set number of laws? The Antonia court at one point said 3 laws. That constitutes a tradition. Other courts have said 7 laws. Some other courts have even said, roughly half the nation having this law does not make it a tradition. So that kind of what a tradition consists of, and then kind of related questions of, how many states had to have adopted them? How long do they have to last for? Does it matter what the population density of the given states, what these particular laws were? A lot of questions about how to apply the test in practice, Bruen left open, and we're seeing the lower courts that are reaching different results. So whether, it's constitutional to bar somebody with a felony indictment from acquiring a new gun, some courts say yes, some courts say no. That's not surprising, right? That's going to happen after any big ruling. But what is surprising, and I think more concerning, is that they're disagreeing about how to actually do the test. So some of them say it's a step 1 issue. Some say it's a step 2 tradition issue versus a plain text issue. Some say, we're applying a test that looks for a distinctly similar analog because this is a type of problem that has persisted from the founding. Some say we apply a different test when it's dramatic technological change or a social problem that hasn't existed. And then we're looking for a relevantly similar analog, which is not the same as a distinctly similar analog. So I think the problem on the practical level is that it's not that courts are reaching different results. It's that courts are applying different tests and are voicing their own confusion about what the test should look like.
Yeah, interesting. I think starting with that practical level issues that you're talking about, wouldn't part of that be just the fact that the court generally has not done many Second Amendment cases, and I would kind of expect to see this. Now I'm not, a constitutional law expert, and I don't know exactly how First Amendment litigation has played out over the years in granular detail,
Mm-hmm.
but I do know that the First Amendment has had dozens and dozens and dozens of cases decided before the Supreme Court over the last century or so. And then the Second Amendment has only had 3, 4, if you count Sertano, 5 if you count Miller, which sort of does the current court does kind of set up as the basis for all of this. That's one of the things I would say is, like, after Heller, they didn't like the way that the courts were trying to reconcile that ruling with current gun laws. And so, Bruen is sort of mostly, I think, a refutation of the 2-step analysis that a lot of lower courts were using, which is one reason, too, that I think it's not necessarily, I'm not really surprised by how many successful claims there have been compared to the period after Heller, because Bruen kind of, while it spends 4 pages just relitigating what Heller says, and this test it lays out is like kind of just, here's what we meant about what we were saying in Heller. Yeah. But it's sort of a step-by-step. It's certainly, you're right that there's not, it's not comprehensive. It's not, it'll be, there's going to be a lot of growing pains in terms of applying it at the lower level to lots of different cases beyond the specifics of a handgun ban or a may issue carry law, because those were the ones that the court specifically looked at. But I kind of expect both a lot of response from the lower courts to that results in more favorable outcomes for Second Amendment advocates because of the nature of the ruling, and then also a lot of disagreement because there's so little to go off of, because there have only been really, I don't know, 2 major cases on the Second Amendment at this point.
Yeah. So I see 2 points there. One is this is just expected because, it's a new decision, and every new decision is going to lead to confusion the immediate aftermath.
Yeah. Especially with such little real
little case law.
Case law in it.
And second, that's notion that what we're seeing is also expected because Bruen's not just a new test, but it's saying repudiating the old test, that you were doing it wrong by upholding too many laws. I think those are absolutely right. I think it's expected that when there's a kind of watershed new Supreme Court opinion, that there will be disruption in the immediate aftermath, that lower courts are going to struggle to figure out just how this should work to new claims that weren't before the court. So there's one level in which it's expected and normal and a part of the constitutional process. At the same time, I think my view is that there are things the court could have done to say, to recognize that it was announcing a new test that hadn't been applied in the previous 15 years of litigation that had built up over between Heller and Bruen. And, there's a change in composition on the Supreme Court that explains why it took the case now. But at least some of the 15 years, there were calls by many advocates over those years that the Supreme Court should have stepped in earlier and said something. And so
probably should have.
The fact that we got, 15 years of precedent built up before the court said that they had been doing it wrong since essentially the year after Heller. I think 2009 is the earliest I've seen the court applying something like the 2-step test. And so, for that to be happening 15 years later, part of it is the court should have acted earlier, right? If the courts were doing it wrong, and obviously personnel changes.
Obviously, I think there is sort of a practical political aspect to this too, because we don't know exactly how the court thinks about things most of the time, outside of when somebody leaks a draft.
Good reporting inside.
Yes. But I was just reading tea leaves on the outside. The court's makeup changing probably did embolden some of the members of the court who are more favorable towards an expansive reading of the Second Amendment to actually take a case finally to go further into depth, because Heller, certainly you can read Heller and get what they're saying in Bruen from it. And a lot of people did make that case. I mean, that's Kavanaugh is the one who came up with this text history tradition standard when he was on the DC Circuit Court of Appeals in another dissent, of course. Yeah. But just like Cantor with Amy Coney Barrett, but they didn't actually do anything. You had some of the justices talking about, Second Amendment being treated as a second class right, and so forth. And, Thomas and Alito and Gorsuch, I think at one point or another had joined dissents on when they would deny these lower court cases, these appeals. So that's a very fair critique. And I think it's one that was very, very much common in the gun rights.
Everybody agrees with that one. Yes. Folks on the gun rights side say I should have done this earlier. Yeah.
Yeah. But, let's get back to some of the core sort of philosophical critiques of the ruling itself, because there's the practical aspect of there's been a bit of a mess in the lower courts on how to apply Bruen, and you can certainly there's probably a lot of things that go into that, whether it's genuine misunderstandings between courts who are acting in good faith, or I'm sure there are gun rights advocates who would accuse certain lower court judges of just, again, the old critique of the 2-step test, whether it's that it was meant to kind of ignore what Heller was saying and get around it. And so I think you had that same critique from gun rights advocates on some of these lower court rulings that uphold laws by applying Bruen in a way that they wouldn't agree with. But going back to the larger conceptual argument, one of the things that you brought up this idea of it's a harder test to do this historical analysis than it is to do, a balancing test that balances government interests against the, rights of people. And one of the critiques of that I've seen in the gun rights space is, for instance, from somebody like Mark Smith, who has argued that, it should be easier for judges to look at something they understand, which is the law, historical statutes, and be able to interpret what those, the how and why of those statutes and whether they are close analogs to a modern statute than doing like social science, balancing based off of whether or not this policy has the right effect. You understand, like the critique is basically judges are actually more suited to do this sort of test than they are to do, a test of whether or not a certain gun policy has the right percentage effect to justify, the balancing it against the rights that are implicated.
Yeah. And I think that's certainly the perspective that Bruen raises in the case itself, where it says, we think this is more administrable than weighing costs and benefits. Right.
Right.
And one of the ways I think it says that is it talks about these default rules and presumptions, including the notion of party presentation, that the courts aren't supposed to be out there roving through archives and doing their own historical research, that the government's burden is to introduce the evidence. And so I think that's, the presumption that Bruen was going off of as well. My view is that, we talked about First Amendment jurisprudence a little bit. Means in scrutiny, intermediate and strict scrutiny is a fundamental feature of current First Amendment law. So this is what courts are doing all over the place when they deal with the First Amendment question. Almost all of the time, if they're not saying that it's categorically unprotected speech, things that have been unprotected forever, like true threats, then they're moving to means in scrutiny, and they're asking questions about what's the government's interest and is this law narrowly tailored to serve the government's interest. So kind of on the other side, which is the notion that whatever may have been the case in like a general understanding of what a judge does, at least for the past, since the 1960s or so, courts have been applying means in scrutiny. They've been doing strict and intermediate scrutiny. And so it's a task that courts are familiar with. And I just want to say, one of the few courts that adopted the two-part framework initially were conservative judges who were trying to faithfully apply Heller. So, I think at least the two-part framework did not arise as a result of judges who wanted to get around Heller. So Judge Diane Sykes on the Seventh Circuit, Judge Anthony Sirica on the Third Circuit, two very early circuit court opinions that they authored where they adopted this two-part framework, and they're conservative judges appointed by Republican presidents. And, my read of those cases is that they thought this was faithful to Heller. It turns out Bruen says that's not the best reading of Heller, but I don't think it was the two-part framework was designed in order to get around Heller. I think it was designed for judges to say, look, we do this in the First Amendment context, and we know the First Amendment is an individual right that's a fundamental individual right that has strong protection in the courts. And so we think this kind of test is the same thing we should do in Second Amendment spaces. But yeah, I think you're right that there's this debate over which one of these kind of two tasks is harder, doing the historical inquiry or looking at historical statutes, or doing this kind of means in scrutiny where you're analyzing the policy effects of a given law. I think both those tasks are hard. And yes, we could certainly disagree over which of those tasks is harder.
Yeah, fair point. And I think maybe it might be a part of a larger effort by the current court to push back on balancing tests generally. Yes. That seems to be the implication in Bruen, at least, from Thomas's opinion. So that part of a larger project.
The critique of in Bruen is not limited to Second Amendment cases. It's more like we don't do this for constitutional rights generally, which might mean that's going to do that for other areas. Yeah,
and obviously the other critique of the two parts. I think one of the main critiques was that a lot of judges weren't really applying intermediate scrutiny. They were applying more of a rational basis.
That intermediate scrutiny applied in too many situations, and that courts were applying it too leniently. Yeah,
right. But either way, the other critique that I hear a lot of about some of these complaints with Bruen deals with the analogy process, right? I mean, obviously, there's going to be some there's wiggle room in that process because, like you pointed out, like what exactly is an acceptable analogy? I think the court in Bruen it seems to be implying that if there's any question, you should go towards the interpretation that is more what's the right word here? More that gives the Second Amendment rights more leeway, I guess would be there. That's how they seem to approach it. But obviously there's an open question of what is a similar analogy to a
Yeah.
modern law from how do the how and why are supposed to match up,
Right.
but how closely, so, and that's why you've seen, a range of answers to that question so far. But the idea that, if they didn't speak on it at the time, that implies that it wasn't constitutional to enact that sort of restriction, this issue that you raised earlier. I think the critique of that is just that there weren't a lot of gun laws at the founding. There weren't a lot of gun restrictions. And most of the backlash to Bruen is just people who wish there had been more and don't like the fact that what that implies in how this standard is supposed to be applied.
Yeah.
Is that
I don't see that as a
critique?
critique, though. I mean, maybe there weren't a lot of gun laws, but maybe that's because there weren't a lot of gun violence problems at the founding, right? And so it doesn't necessarily shed light on the question that originalists should be asking is, if they confronted the same problems, what did they think the tools they could have used were, right? And so if they had problems of frequent mass shootings or widespread community violence in urban centers, then what did they think the Second Amendment would have allowed legislatures to do, right? That should be the originalist question.
And you don't see the analogy that because, like you mentioned, there is sort of a mechanism for this in Bruen where they admit that, there's been technological advancements, there's new societal issues that have come out of that. And so in those cases, you can use a little bit broader view of what's analogous.
You can use a little bit,
but you
broader.
don't think that addresses this
Well,
issue.
I don't think it addresses it because you can use, all it does is say, if you have an old law, then you can kind of you can apply the analogousness restriction a little bit looser, right? So you can find one that's not exactly the same, but it's similar, but maybe not as similar as you'd be required to find if it was the same problem, like, say, felon firearm violence, right? Which the court seems to suggest is the same. If there was just no legislation at all because it wasn't a problem at the founding era, then the loosening of the restriction with analogousness doesn't really help because there just were no laws, right? And so I don't think it's a complete answer. Sure, it certainly helps when you're talking about if we have a set of laws that we're looking at, how closely are we going to require those to mirror the laws in contemporary times, then I think it does make sense what the court says, which is if there are huge changes in the issue that's being dealt with today, then we should relax the restriction on analogies a little bit. But that doesn't fully answer the concern because it doesn't tell us what to do where there were no laws, even if we had good evidence that they thought that they could legislate on it if there was a problem. Even if we have, tons of evidence, lots of legislators saying, lots of letters between founding generation individuals saying, we could do this, but we don't see the need to do it. Even if we had that kind of evidence, Bruen seems to me to say that doesn't make a difference unless you have an enacted law on the topic. That's the only thing that we're looking for.
Okay, interesting. Well, so can you tell people where they can find your paper, where they can read more from you on this topic if they want to do that?
Yeah, so you can find my paper on SSRN is a database where lots of legal scholars will post drafts of forthcoming articles. So this article is going to be published in the Duke Law Journal in October, but it's called The Dead Hands of a Silent Past, Bruen, Gun Rights and the Shackles of History. I also did a blog post on it at the Duke Center for Firearms Laws, Second Thoughts blog, and it was called By the Numbers, How Disruptive Has Bruen Been? So that's a couple places where you can find my writing on this.
And we linked it in our piece on the topic as well. So people can head out there and read it. It's obviously much longer and there's a lot more to it than we could get into today on this podcast. But we do appreciate you coming on and spending some time with us and giving your point of view. I think is very valuable for people to understand, where you're coming from and some of your critiques of Bruen and have this good conversation that we've had. So I really appreciate that.
Yeah, thanks for having me. I appreciate it too.
Yeah, and we'll have to have you on again in the future as well.
Sounds good. Maybe for Rahimi.
Yes. Yeah, maybe. We'll see what the court does with that. It does seem like usually they take those cases, right? When it's appealed by the government.
When it's appealed by the government and it strikes down a federal law, usually high chances.
Yeah. So we'll see if maybe they'll start taking some other cases too. I mean, like we mentioned here, they could use some more case law on the subject.
That would help with the problems of lower courts trying to figure out what to do. Exactly.
Absolutely. All right. Well, we will absolutely have you on again in the future. Right now, we're going to head over to our news update. All right. We're joined again this week by contributing writer Jake Fogelman to give us some news updates. How are you doing, Jake? How's the transition to spring treating you?
It's a little bit bittersweet. Weather's been getting pretty nice out here in Colorado after a pretty bitterly cold winter. So it's starting to get sunny and nice. But with that comes spring allergies. I get really bad spring allergies, and they're just starting to kick in for the first time this year. And that's been a little rough. But other than that, I can't complain. How have you been?
I'm good. I'm actually headed up to the farm, my mom's farm up in Pennsylvania this weekend to take care of the horses. I really just for a night. And then because I have to come back for Saturday. My girlfriend's going through the naturalization process. So that's exciting. She's from the Philippines originally. But yeah, and then on Sunday, actually, I'm finishing up my DC, Maryland concealed carry training course. So that's a positive thing. Of course, I actually have scheduled my application drop off already with Metro Police Department in DC, and the closest available date is June 14th. So about 3 months from now, and that's just to drop off the application. They still have 90 days to actually process the application, which consists, I'm not sure what they're doing beyond a background check that every other state does in an instant. Literally, it's an instantaneous process when you go and buy a gun, for instance. But I'm not sure what else they do during that process, if anything, frankly. But around here, they generally do take those full 90 days to actually issue you a permit because, they just don't want people to have them is the bottom line. Of course, the whole process, the application process is about $100. And then on top of that, you have the training requirements, which costs probably around $350 when you combine the cost of the class. And I have a pretty good deal on my course. But even with that, it's still probably about $350 when you consider the range costs and ammo costs to go through the course. And of course, 2 hours of that class are range time, which is an issue because DC doesn't have a public range anywhere in the city. And so if you live in the city, and the other complication is you can't transport firearms on public transit. So unlike in Virginia and Maryland, in the metro system here, the trains, the subway, they service DC, Maryland, and Virginia. And in Virginia and Maryland, if you have a permit, you can carry legally on those on the trains. But in DC, you can't. There's a specific law in DC that says you can't carry on any public transit, buses or trains. So if you live in DC and you're not particularly well off, it's fairly difficult for you to actually get one of these permits in reality, which frankly is probably exactly why they're designed the way they are.
Right. I was going to say it's probably a feature rather than a bug in their eyes.
Yeah. I think that's safe to say. In fact, there's an ongoing lawsuit against the MPD gun recovery unit that claims they systematically target African-American men in low-income neighborhoods for basically stop and frisk procedures that were made famous in New York, and essentially stopping people with no reasonable suspicion to do so. I actually plan to write about that soon here. I did an interview with the lawyers in that case. But anyway, so there are deeper problems that come out of these gun laws the way they're written, because that stop and frisk was enforcing the New York concealed carry law, which was almost literally impossible for a regular person to actually get a permit. And while this bar is not quite the same in DC now as it was in New York City then, it's still extremely high for someone who's not well off. But anyway, for comparison, I got the notice that my Pennsylvania non-resident concealed carry permit has been approved, and I just have to go pick it up, which I'm planning to do on Friday. That process cost $26 and took less than a month. So
It is always funny how some jurisdictions manage to make it so easy, and they can somehow manage the big workload and keep the fees low.
Yeah.
And then others, it apparently is quite the task.
yes, and of course, obviously now we've got 25 states where you don't need a permit at all to carry a gun. So that's really that the whole system is changing for the better. If you obviously, depending on your point of view, but if you are a concealed carrier or you believe in concealed carry, it's changing for the better over time here. But anyway, so that's what I'm up to. Getting back to news of the week, we actually have very terrible story to talk about, which I'm sure everyone has already heard. And we also have a few stories sort of connected to this that we've written about. There was the school shooting in Nashville, Tennessee, that left 3 children dead and 3 adults as well. And, just a horrendous situation. I've been on CNN and C-SPAN talking about it a lot this week. Very hard, very, very hard situation, very, very disturbing. The police response, I've just talked about this on Active Self-Protection's podcast. Anyone who likes this podcast should really go and check that podcast out, because they'll probably really enjoy that as well. But we talked about the police response, the badge cams that came out, and I can't compliment that enough. I mean, those guys did exactly what you're supposed to do. I think that's going to be the example that everyone points to going forward in active shooter response classes. I've taken several of them over the years, and those guys were on point. They're well trained. They communicated, and they had urgency, and they were able to, about 4 minutes after they entered that building, neutralize that shooter. And I think they saved a lot of lives. So thank God for those guys.
Absolutely.
But 2 of the stories we've written about that sort of connect to this, because the shooter did use, they had 3 guns on them. One was an AR-15 pistol. One was a sub 2000, a 9mm pistol caliber carbine, and one was a handgun, a 9mm handgun. And so there's been a lot of discussion, as there always is after an event like this, about AR-15s and so-called assault weapons. I think the sub 2000 would probably fall under most states' assault weapons bans. So we had 2 significant stories. One you wrote about, which is actually one of the first major polls specifically of AR-15 owners. Can you tell us a little bit about that poll?
Sure, yeah. So this was a project of the Washington Post, sort of a joint project with Ipsos, which is like a polling firm. And as you said, they conducted an AR-15 owner specific poll as sort of a subset of one of their gun polls that they run regularly. They actually ran this last fall, but they are just now releasing it because they did a big series of pieces on the AR-15.
Right.
But what was interesting about
of quality, in my opinion, this piece.
That's right. I say that's right. There were certainly some questionable information in some of the other pieces, but as you said, this poll was cool to see. Yeah, it was a reputable pollster that conducted it, and what they found, one of the big takeaways from this poll, is they were able to come up with an estimate based on their polling samples to see just how many people they think own an AR-15 or a similar rifle, and what they came down to was about 6%, or about 1 in 20 Americans, they say, own an AR-15. Which in raw numbers, that comes out to about 16 million people, which a rough estimate, but that's, 16 million is a pretty sizable proportion of the population.
Yeah. Well, that's people who currently self-report as being AR-15 owners. So
right.
They own one right now. And this does line up fairly well, as you wrote, with some of the other estimates we've seen. The National Shooting Sports Foundation has estimated there were 24.4 million AR-15s and AK-47s sold between now and 1990. So 16 million owners would be, more than one gun per owner, but that's not entirely unreasonable assumption. And then there was also the National Firearms Survey, I believe it's called, right, from the Georgetown professor, William English. He found his estimate was a bit higher, but he looked at anyone who's ever owned an AR-15 or similar firearm, right?
That's right. Yeah. So he surveyed just gun owners generally across the country, and he found about 30% of gun owners said that they either do or have owned an AR-15 or similar styled rifle. And that came out to about 24.6 million people. So it's a little bit higher than the 16 million. But when you count that the question included folks that maybe at one point owned an AR-15, it's in the ballpark.
Mm-hmm. Yeah. So pretty big numbers as we would expect to see in this. What were some of the breakdowns on why the people said they owned AR-15s?
Yeah, well, this was pretty interesting. The number one self-reported reason for why AR-15 owners purchased their AR-15 was self-defense. This sort of tracks with broader trends in gun culture overall, where self-defense is overwhelmingly the number one reason people purchase guns, period. So I guess it sort of makes sense that AR-15 owners would also quote that. About 1/3 of the AR-15 owners they surveyed listed that as their primary reason, but upwards of 66% said it was a major reason. So it's clearly on the front of mind for folks that own these rifles. Yeah,
and then I guess demographically there was some interesting stuff too. For instance, military service. There was an interesting bit about military service in there.
That's right. Yeah. So not only were AR-15 owners more likely to have a past of military service than Americans overall, but they were also more likely to have served in the military than just your typical gun owner. It still was a minority of AR-15 owners that said they had served. I believe it was something like a quarter. But still,
but I think only like 7%. Yeah, and only like 7% of the population has served in the military. So we have a quarter of AR-15 owners have done it. That means they're significantly more likely to, an AR-15 owner is significantly more likely to have military service than your average American, which is interesting. I mean, it makes sense, right? Because the AR-15 is the same pattern rifle as an M4 or M16. It's obviously it's the semi-automatic only version of that firearm. But if you're coming from using that gun in the military, you're going to be used to the controls and how to operate it safely and effectively. So it makes sense that would be a common gun that you see veterans, picking up for themselves.
Yeah, no, absolutely. And it's funny, they actually polled that question specifically. They asked among those veterans, was your time in service a deciding factor in you purchasing an AR-15? And it's funny, it was actually a lower number than you would think. I think only something like 4% said that was their main reason. But as you said, that could still be a contributing factor to when deciding for one rifle versus another particular weapon for self-defense, for example.
It might not be their main reason, but I'm sure it was a contributing factor for a lot of them, I would imagine, when you're trained on a gun, and it's one that was reliable for you in your time in the service, then it would make sense. But it's similar to why a 1911 was so popular and remains so popular today, because that was the sidearm for the Army for 80 years and even still sees service with some units today. But, that remains incredibly popular because of that, or partially because of that at the very least. Interesting stuff out of that poll. And then we also had, of course, another development out of Delaware this time, right? A federal judge ruled on that state's new so-called assault weapons ban.
Yeah, no, that's right. And it's funny because there's sort of a linking factor here where we have documented polling data to suggest that, anywhere between 16 to 24 million, depending on which one of these sources we've covered, 16 to 24 million people own these rifles, which you could use that to make an argument that these things are in common use and in common use for self-defense when that's the number one reason cited, right? Sure. And then you get to this case where gun rights groups were challenging Delaware's state assault weapon ban and their ban on quote unquote high capacity magazines. And the judge in that case, he agreed. He said, AR-15s and similar rifles, and as well as these magazines, they are in common use for self-defense. But nevertheless, he declined to issue an injunction blocking both of those laws.
Because that was the big twist.
Right. It's sort of like, whoa, hard left turn there.
When I first read, I think Rob Romano on Twitter, he works for the Firearms Policy Coalition, but he tweets out a lot of these decisions as they come out. And he was the first one I saw tweet about it. And his thread confused me so much because, his first tweet is like, oh, he denied this injunction. But then his following tweets were like, oh, he found that AR-15s and so-called assault weapons are in common use. They're in common use for self-defense purposes. They're the standard. It's not dangerous or unusual. It's dangerous and unusual, which these wouldn't qualify for. And then at the end, it's like, oh no, yeah, but he still said you can ban them. And so that was pretty surprising to see, right? Because I mean, the court, this sort of base level ruling in Heller was that any firearm that's in common use for lawful purposes, like self-defense, would be presumptively protected by the Second Amendment, which is what he agreed with, right? But then there's a twist after that.
That's right. Yeah, no, I was going to say, he even specifically says, yes, these AR-15s and large capacity magazines are covered by the Second Amendment. However, one weird trick, there's been these guns and these magazines, they represent a quote unquote dramatic technological change, and they bring unprecedented concerns for public safety.
Right. And that comes from Bruen.
Right. And so therefore, he pointed to sort of analogous laws, depending on your point of view, on, late 19th century, sometimes 20th century bans on things like Bowie knives and, billy clubs, and concealed carry as well. Some of the stuff we've seen in other gun cases, basically pointed to those as analogs for why, despite everything that he laid out before about these firearms being in common use for self-defense, that they can actually be regulated, and therefore he did not block Delaware's law.
Yeah, it was very interesting ruling. And one of the interesting things about it too is that it's not the first time we've seen this reasoning, right?
That's right. Yeah, no, it's very similar to that Oregon case, the federal version of the Oregon case for their ballot measure that instituted a permit to purchase requirement and a magazine ban as well. And the judge in that case made a very, very similar argument for why she was unwilling to block that law before it took effect. So it's clearly something's coming together here where this is going to be a new argument that at least some judges are willing to use.
Yeah, this seems like this will be the template for how judges who are inclined to do so try to uphold assault weapons bans and magazine restrictions around the country. So don't be surprised to see this line of thinking pop up again down the road, especially when you get to like the Ninth Circuit or the Fourth Circuit reviewing these sorts of laws. Because I think that's where the gun control movement has coalesced on the legal argument side here. And so that's what I predicted actually after the Oregon ruling was handed down, the denial of the TRO, the temporary restraining order. I looked at that reasoning. I thought, okay, this is a more solid attempt to come to terms with Bruen, and while also upholding these modern hardware bans. And yeah, here it is again. We've seen it pop up once more. It's not a coincidence, right? I mean, this is the arguments that they make in the case, right? It doesn't come from the judges, really. The judges hear the arguments and then they decide whose side they think was more persuasive. And so this is the line that you're seeing from states around the country trying to defend their restrictions. And I don't think it's going to last long, frankly. I don't think this is something the Supreme Court is going to be okay with. Now, it may require them to actually get involved in a case and take a case for that to really matter. But one of the big flaws in this reasoning, besides the fact that I think the court would just say, once you've got, it's very similar to how they talked about the two-step analysis, right? That lower courts used to use to uphold gun laws, and they called it, one step too many. Right. And that's kind of what this feels like too, right? After you determine that class of firearms is in common use for a lawful purpose, I think the court just wants you to stop there. Like you can't ban those things. It would be sort of the obvious conclusion, I think, from reading Heller and Bruen. But, the other issue is that by this logic he's using, he's arguing that, semi-automatic firearms and magazines that hold multiple rounds of ammunition weren't Not that they didn't exist at the founding, because they did. Repeating shot firearms and magazines existed at the founding. And he notes that. And so did the Oregon judge. But they weren't popular as the idea. They didn't become popular until, really the late 19th, early 20th centuries. So therefore, the idea is that, you can ban them essentially with that logic we just described there. And of course, the problem with that is it's a logic that allows you, there's really not much of a limiting factor there. You could ban semi-automatic handguns, all of them, under this reasoning, and really all magazines.
Right.
I mean, that's sort of the implication that you get at here. And I don't see that seems to obviously conflict with Heller, which was about banning handguns.
Right.
So anyway, we don't know how that's going to play out. That's just my analysis of where the issues, the weak points of this ruling. But frankly, it's going to take a while longer to get to that conclusion, because you're still going to have to go through the other higher courts. And it's not clear that, especially in circuits where they have these laws, that the higher courts would be inclined not to adopt this exact same kind of reasoning.
Yeah, I think that's right. I think it'll likely take Supreme Court stepping in to actually nip that in the bud for that exact reason.
Exactly. And I should note that I have talked to the Delaware the Delaware gun rights group that brought this case, and they have told me that they are going to appeal this decision. So we will see more on this case moving forward, and we will, of course, follow that here at The Reload. But that's all we've got for this week. If you appreciate the reporting that we do, if you want to support us, please like and share this episode. Go ahead, leave a comment on YouTube if you'd like, or leave a rating on whatever podcast app you're listening to this on. That really helps us out a lot. Of course, if you want to go a step further and gain access to exclusive content that you won't get anywhere else, and get this podcast a day early, plus the opportunity to appear on the show yourself if you'd like in a member segment, then you can head over to thereload.com and buy a membership today. That is how we run our business. We have no investors there's no corporate overlord. This is an independent and informed publication where readers are the ones who fund our work. So please head over and check out membership options today if that's something that interests you. But that's all we've got for this week. We will see you again soon.